May it please Your Lordship, I beg to mention item number 7, Your Lordship. Since the conducting counsel is on sanction leave, Your Lordship, I pray that the matter may come after 2 weeks. I have already informed the opposite party, also is not here, Your Lordship.
Why 4 weeks?
Your Lordship?
Why 4 weeks?
2 weeks, Your Lordship.
2 weeks. On pre-made by the petitioner, this is matter up to 2 weeks.
Oblige, Your Lordship.
Lordship, I beg to mention item number 1. Lordship, the conducting counsel is indisposed.
Item number 1.
Yes, Lordship. Sir,
You are appealing for?
for the respondent, Lordship, respondent number 4.
Yes. Anything?
I have no objection, Your Lordship.
No, not yet.
On pre-made by the respondent number 4, the same not being objected to by the petitioner, matter is adjourned. This is same after 1 week.
Lordship, 2 weeks if possible.
Why 2 weeks? 2020 matter. 3 years down the line, nothing has happened. We're not even sure whether it will be admitted or not. 1 week.
Lordship, I beg to mention item number 9. The conducting counsel is out of station, Lordship.
Yes, Mr. Kanda.
I have no objection, Your Lordship. This is the third time, no? You asked for time.
On pre-made, you are for respondent?
For the respondent.
Only respondent.
Only sole respondent.
Sole respondent.
On pre-made by the respondent, on the ground that the conducting counsel is indisposed,
Out of station, Lordship.
is out of station, the same not being objected to by the petitioner, that is adjourned. This is same after
2 weeks, Lordship.
2 weeks. Anymore?
2 more are there.
Yes, anything else?
Lordship.
What else?
Lordship, I beg to mention item number 5. Lordship, in this matter, Lordship will be placing some relevant judgments on the basis of which the conducting counsel will make his submission.
Lordship,
As per the
the
instruction
case
of
is,
department, Lordship.
they are asking time in a very routine manner. Almost every date. It is the discharge order passed by the trial court, and they have assailed this order before the trial court. Now it is them to open the court, open the case and say that the order passed by the trial court is correct or not correct. So they are not arguing the matters. Sometimes they say they are take the instruction from the client.
Lordship, as per the instruction given by the department, Lordship, we have to place certain relevant judgments
Judgment, Lordship,
on the basis of which
Oh, that is
arguments will be
that will be in course of hearing.
course of hearing only, yes. For that.
2017 matter. If we go on like this,
No, see, only my observation that by this number 3.
we'll give you 1 week. Get it done. No more adjournment. On pre-made by the on behalf of the petitioner, on the ground that the ASG is out of station. The matter is adjourned. This is the same after 1 week.
Lordship, I also beg to mention item number 6.
This way, nothing could be done.
Yeah.
This is also 2020 matter. Same order.
Lordship.
And for the
1
rest,
week,
state
2
response.
weeks. 1 week,
2 weeks, Lordship.
2 weeks.
State response.
Kindly oblige, Lordship.
Daily costless item number 2.
Please, Lordship. I beg to pray for 3 weeks further time, Lordship, to file the rejoinder affidavit to the affidavit of respondent number 1 to 8. And as far as number 9, 10, and 11, they have also not filed the affidavit.
Lordship, I pray for some more time, Lordship.
Yet again, the petitioner has sought for time to file the rejoinder to the counter affidavit filed by the respondent 1 to 8 respectively, on the ground that the same could not be prepared. Similarly, the legal counsel for the respondent 9 to 11 has also sought for time to file the counter affidavit. On consideration of the submission made, of the prayer made, the same is allowed. The parties are to ensure that they take necessary steps within the next date fix.
Within next date, I will file, Lordship. Within next date, I will file. 3 weeks time may be granted.
This is matter of the 3 weeks.
Highly obliged.
Item number 3.
Please, Your Lordship, will be issue notice, Your Lordship, to the respondent for this continuation, Your Lordship.
You have not done so.
Your Lordship, we just got a call this. We're appearing today, Your Lordship, because we just got a call this morning for the appearance.
You are for?
And for the petitioner, Your Lordship. There's a continuation, Your Lordship. Delay of 50 days.
Miss counsel for the petitioner has submitted that. Notice may be allowed to be issued upon the. How many respondents are there?
Yeah. 9, Your Lordship, along with the state.
On the respondents, as far as this application for condonation of delay in filing the review petition is concerned, accordingly the same is allowed. Let steps be taken. The same, let notice be issued. The same returnable within 2 weeks. List the matter accordingly.
Much obliged, Your Lordship.
Item number 4.
For respondent number 1, 2, and 3.
May I please, Lordship? We have already filed our rejoinder affidavit.
We have received.
You are a petitioner.
Yes, Your Lordship.
You have filed a rejoinder.
Yes, Your Lordship. I'm praying for 2 weeks time, Your Lordship.
You are not going to file any. The legal counsel for the petitioner has submitted that the rejoinder to the counter affidavit filed by the respondents 1, 2, and 3 respectively has been filed. Pleadings being completed, the legal counsel has submitted that this matter may be posted for hearing. after 2 weeks. List the matter accordingly.
It's a pleasure, Lordship.
Item number 8.
May it please your lordship, my lord, on the last occasion, that is 31st August, my lord has allowed me 2 weeks time to bring on record certain documents which I wanted to rely. I am filing in the course of the day, my lord, because some personal problem with the president, my lord. He could not come. He is on the way. I'll file it on the course of the day. Let it come with for hearing on next week, my lord. Next week or day after that, my lord, as my lord's convenience.
The counter affidavit has been filed.
Yes, my lord. It is actually ripe for argument, my lord. In fact, it is in the hearing list. But then what happened is that on the last date, recently there was an order passed by the corporation saying that all the casual workers who have attended the age of 54, which is the retiring age on superannuation for the regular employees also, should retire.
54.
I'm sorry?
54.
Age of 58, I'm sorry, 58, my lord. So that is very important for my case, because I'm trying to establish my case that we are not the ordinary casual workers who just come on a need basis. We are a long-standing casual workers who are doing a regular job, and this is pertaining to praying for an equal pay, for an equal work on the basis of the Honorable Supreme Court's judgment passed in Jagjit Singh's case, my lord. And this particular order,
But you are not, your services have not been regularized.
no, our services have not been
You
regularized.
are not seeking for regularization.
No, in this petition, we are not seeking for regularization. We are only saying that the same nature of job that we are doing, the permanent people are also doing. So at least minimum pay
Where is
wages.
that? But where is that logic?
No, my lord. There's a certain there's a lots of judgment in this. Otherwise, then it amounts to exploiting, my lord.
As far as the nature of work is concerned,
Yes,
perhaps.
yes.
See, but when it comes to the mode of of appointment,
Appointment, my lord.
you have been appointed on a different footing,
Yes, yes.
whereas
Yes.
others have been appointed through the
On a different, yes,
regular
that,
process.
yes, that is the entry point to the job is we're not disputing, but the thing is that we are a long-standing casual workers who are doing a regular job. Therefore, we are entitled to, it's a become a legal right to at least be paid the minimum pay scale that the regulars are getting paid. That is only prayer that we are asking, my lord, because then otherwise then we are doing the same, like for example, we are doing a Mali job. Permanent is also doing a Mali job. The same natures, hours also the same hours that we are putting. And for example, the linesman, my lord, the linesman, we are taking the same amount of the risk. In fact, many of them have died due to electrocution also, my lord. So the risk also that we are taking the same amount. But when it comes to payment,
There is no dispute to that.
yes, my lord.
The only thing that here, what is involved is a policy matter is there,
Exactly, my lord.
and the fact that again
Yes.
your appointment is not through the normal course.
Yes,
Of
yes.
service.
Yes.
Service matter for that.
Yes, my lord.
So,
But my lord, that is, but then that is not only the relevant factor because of which we can be denied the equal pay, my lord. That is not exactly the primary factors to deny us, my lord. There are so many other factors, my lord, which would I will satisfy, my lord. Let me bring on record
that is
this.
only
Yes.
you are only demanding pay.
Pay, my lord.
For
Yes.
for the length of your service.
Yes, yes, my lord.
Not
Not
pensionary
regularization
benefits.
in this or any other benefits right now, my lord. We will let me just bring this one on records, my lord, then we can have it for a final disposal, this case, my lord.
My lord, if my friend my friend was to file an affidavit which he has not filed, because if he filed this, my lord, I will be also required to take instruction or to file a counter to that, my lord.
Yes, of course.
So,
Yeah,
my lord,
that is-
so
can't
that,
respond to
that
it.
should be given to us as some other opportunity.
Yes. So a week's time to file, and then another week's time for
For
them
us to
to
respond.
file rejoinder, anything, then let it come after 2 weeks, so for final hearing.
Mr. P. Owen, Direct Counsel for the petitioner, has submitted that the affidavit to bring on record certain relevant documents as was allowed by this court by its order dated 31/8/2023. Could not be done so today, and as such accommodation is sought for the same to be filed within the next date fix.
My lord.
Ms. Arkulli, the Red Counsel for the your respondent.
My lord, I'm respondent number
All the
2 and 3, my lord. MBCA.
State is not.
State is one, my lord.
It is,
Formal party.
it's a corporation, but it's,
The answer
But
is
why have you made the state a
my lord, because this is also because the fund and everything. I think the states are doing in this.
But the corporation is a corporation.
Corporation, my lord.
It may be a government
Yes.
corporation.
My lord.
But it has its own
We can treat that as a formal party, my lord, the state.
My state has been
unnecessarily,
appearing as formal party only, my lord, here.
necessarily.
My lord.
Then they will be called upon to also respond, and
No, they
may-
have
they may
actually
not-
denied
they
to.
may not.
Yes, my lord. They have actually
No,
denied.
they have recused from filing
Recused
any
from
affidavit, my
filing
lord.
the affidavit, my lord.
We are contesting, my lord. Corporation is contesting this.
I move to has also submitted that the respondents 2 and 3 may be allowed to respond to such affidavit if so filed. Accordingly, the petitioners association, you call yourself association or organization?
Yes,
or
my lord. This is an association,
Association,
registered
my lord.
association.
petitioners association? Yes. Hangtoga per I association is allowed to file the said affidavit and an advance copy to be furnished on the said respondents, upon the respondents, who shall then file a response if so advised within the next date fix.
My lord.
As prayed for, this is matter after 2 weeks.
My lord. Obliged.
Yeah.
She's on live, that's why.